Welcome to Civil Justice for SA Survivors.
Welcome back to Civil Justice for SA Survivors with attorneys Marc Pearlman and Melissa Anderson. Marc and Melissa represent survivors of SA or sexual assault and exploitation throughout Illinois. They're focusing on accountability and safety through the civil justice process. I'm Lisa Mosby, your host, and today we're talking about what happens when the criminal system can't or won't move forward and how the civil courts can still provide a path to justice. Welcome, Melissa. Welcome, Marc.
Hi.
Hi, thank you.
For listeners who may not know the difference, how do criminal and civil cases work side by side? And why do so many SA survivors end up turning to the civil system?
The criminal court system, first of all, is brought by criminal charges are brought by the state or the federal government as opposed to by private attorneys who you go out and hire. So actually, when there is a criminal case, the victim of the crime is not a party to that case. They're simply a witness. The case is the state against the perpetrator for the crime. So while oftentimes there is a sense of empowerment because the perpetrator and or the institution that caused harm could be criminally prosecuted, it really isn't intended to address the victim's need as much as the civil court system is. And in that regard, there's just much broader remedies available in the civil system that will provide healing and justice for a survivor. The other thing is that the burden of proof in a criminal case is significantly higher than it is in a civil case. In a criminal case, it's beyond a reasonable doubt. So, in a crime like SA, where there's typically no witnesses, it's often very difficult to prove that crime. In the civil justice system, the burden of proof is just, it's a preponderance of the evidence. Is it more likely than not that this occurred?
And sometimes survivors assume that if no criminal charges are filed, there's nothing more they can do. What do you tell someone who feels the system has already closed the door on them?
That's often why people end up pursuing civil justice instead. Often they feel let down by the criminal justice system. Because of the burden of proof, a lot of times there are not charges even brought. So it doesn't even get to the point where someone's even arrested for some of these crimes or then charged with the crime. So coming to whether or not there's been a criminal prosecution prior to someone bringing a civil suit is almost irrelevant in whether or not a civil claim is brought. Most of our cases, there hasn't been anything happening in the criminal process. Sometimes after they've called us, it's not until after they've made that call that the authorities are even told that this has happened. So there really is very little connection in terms of whether or not someone was successful in a criminal trial against their perpetrator, or whether or not they can then be successful in pursuing something from a civil standpoint.
And even if you go to the law enforcement and they don't file charges for whatever reason, and there could be lots of reasons, it's typically not that they don't believe the person. It's typically that they can't satisfy the burden of proof. There isn't enough evidence. It's one person's word against another person. So whether or not the state pursues a criminal action has no bearing at all on whether they can bring a civil action. The criminal action, it's the decision maker is, does this prosecutor want to bring a criminal action? In a civil action, it's the victim gets to decide whether he or she wants to bring a civil action.
And a follow-up to that is, what are some common reasons that a prosecutor might decline to file criminal charges, or even when serious harm has occurred?
Oftentimes it's, as Marc said, it's there because of the nature of SA. the only witnesses are the perpetrator and the victim. So a lot of times there's very little evidence. There can be physical evidence if somebody immediately does go and report the crime. Often that's not the case. So it's usually a burden of proof and evidentiary decision. And we don't have necessarily those same hurdles in a civil case. Oftentimes, we are not, there is some level of proof in terms of proving that somebody was a victim of SA, but it's often enough their word that this is what has happened to them. A jury can decide how much weight to put on someone's testimony and whether or not they're believable. And, very few people lie about being sexually assaulted. It's just a fact that, that people tend to be believed in terms of when they come. We certainly believe our clients when they come forward and they share their story, but that's often with medical testimony and psychologists and therapists testifying after speaking with our clients. We don't often find our hurdle being whether or not our client is believed. That's usually not the hurdle that we would face in our pursuing civil justice.
And there's often times where, one of the questions we'll ask our clients when they come forward, if they come forward to us before they come forward to the police, we'll ask them about the facts and we'll evaluate the legal issues. And we've actually assisted our clients in going to law enforcement and assisting in bringing a criminal case. So while we can't do it, we could certainly assist them in trying to pursue criminal case as well.
So when civil cases focus on institutions like schools, youth programs, or churches, how is that enabled or ignored? That abuse is enabled or ignored. How does that expand the scope of justice beyond what a criminal case can address?
Yeah, so unfortunately, there aren't very many criminal cases against institutions for their role in certain criminal activity. So with respect to the institutions that enable this kind of conduct, the only viable option usually is the civil courts. And in the civil courts, the remedy that you can get for the client is much, much broader. In a criminal case, the remedy is punishment of the perpetrator. In a civil case, it's not limited to monetary recovery. I tell this story all the time. Melissa's heard this story probably 1,000 times now. But one of the most satisfying cases we ever had was we represented a woman who was sexually abused on a boat. And we were asking her in one of our consultations, what did she want to get out of this in terms of her healing? And she said, I'd love to find that boat and blow it up in the harbor in Chicago because all of my sexual abuse occurred on that boat. And then she laughed. And we said, no, that's very real. What you just said is really, really real. And we went to the institution that was involved and we told them that we wanted them to find the boat. And they traced down title to the boat. They found it. They were going to, it was in Louisiana, I believe, if my memory serves me. And they were going to bring the boat back from Louisiana. They were going to purchase the boat, bring it back from Louisiana to Chicago. The hiccup was the Chicago Park District, which runs Lake Michigan and the harbors, said, we can't let you blow up a boat in the harbor. So, but when we told the woman that was the most important aspect of this case to her. And while it didn't happen, we took it very, very seriously, as did the institution. And that was what, and she had a significant monetary settlement. And, for years after that, she would say without failure or pause that the most critical part of the case was that we took seriously her desire to have that boat brought back and destroyed.
Wow, that makes sense. I mean, I would have never in a million years thought of how something like that, a statement that a survivor would make, could make such a difference in their healing. For those survivors who went through a criminal process years ago and felt dismissed or disbelieved, how can a civil case help them reclaim their voice?
I think a lot of it has to do with the control they have over the process. Often is a lot more in the civil process, and in terms of being believed, often in a criminal case, the victim's not necessarily always heard from. A lot of those cases, the cases plead, where the victim never ends up testifying. Usually in our process, and when I say usually, 99% of the time in our process, part of it is having our clients be heard, having our clients be given the opportunity to tell their story to the institution that's responsible. Often the perpetrator's not involved in that regard, but our clients like us often think the real responsible party is the institution that knew that this was going on and did nothing to prevent it or stop it. And so our clients feel, even if they've been let down by the criminal process and not felt heard, because of the way we insist usually that our process includes an opportunity for our clients to tell their story and to say how they feel about it and how it's impacted their life. And that is huge in terms of them feeling heard and believed.
And as we've talked about in past episodes, the criminal justice system really focuses on justice, not healing. It might provide some healing. The civil process, at least the way we handle these claims, the focus is on the client and their healing.
And I'm curious how you approach these cases so that survivors feel empowered rather than re traumatized. It's got to be intimidating confronting powerful institutions and sharing your story. How do you approach that?
Well, not only is it intimidating, but going to a lawyer, who lawyers are by nature controlling, assert a lot of power, and we're really, really cognizant of all of that, and that we have to really dial that back and not make it a much more give and take discussion, and do more listening than talking. That's not easy for lawyers. Lawyers like to talk. We really, really focus on listening and trying to appreciate what our client is dealing with, what healing and justice means to them, and then working with them collaboratively to figure out how to achieve that.
Yeah, and often in the control piece of things. So even if we have an idea of what our process involves and what sort of information our client will be required to make available to the institution. Oftentimes there's an exchange of medical records or employment history, things like that. We never tell our clients, you have to do this if you want to pursue your claim. There's really always an alternative. So if there's something that makes a client really uncomfortable, we tell them, okay, then we don't do that. And here's the consequence of that, or here's how we will perhaps have to rework things. But there's very little in our process, the way we try to design our process in the most trauma-informed way, so that most, if not all, decisions are our clients' decisions. We advise them about the impact of doing or not doing a particular thing in the process, and it's their call. If they don't want to sit down and tell their story, they don't. But our hope is always by that point in the process they'll feel empowered to do that. But really we give them as much control over it as we can.
I'm hearing that in every one of your answers, is that the entire goal is to give them control, to let them make decisions, and to feel empowered through the entire process. So I applaud you for that. Let's wrap this up. For anyone listening who thought that there was nothing left for them to do, what would you want them to know about the hope and control that still exists in the civil justice system for them?
Yeah, I would say that I want them to know that it's safe to come forward. It's safe, it's confidential, and that that if you consult with and hire the right people, the process can lead to a lot of healing and justice, that an empowerment and control that you haven't had in your life for a long, long time. And it's not, you can get it back. And when you get it back, it is really, really, the greatest compliment we could ever get is when a client calls us after a case has been resolved and tells us how different their life is at the conclusion of the case than it was when they first called us. That's the greatest compliment.
Melissa, Marc, thank you so much again for being with me today. That's it for today's episode of Civil Justice for SA Survivors with Marc Pearlman and Melissa Anderson. To learn more or reach their team confidentially, visit pearlmananderson.com. And for resources or more information, you'll have access there as well. You can follow Civil Justice for SA Survivors wherever you listen to podcasts to hear future conversations like this one. So go ahead and like and follow, and we'll see you next week. Thanks, everyone.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.